So this is a confidentiality and non-disclosure agreement. You can see that what you'll put here is the name of the party and the jurisdiction of incorporation, as well as the second party. So two-party agreement is a pretty simple confidentiality agreement, which sets out the respective obligations of parties sharing proprietary information. What's very important here is that you put the description of the purpose for which you are sharing. That's very important. So it's clear to set out the expectations of both parties with respect to information sharing. The next important thing in this contract is the description of the confidential information. It's really important that you specify in clear terms what is in fact being regarded as confidential, right? And if there are any particular discussions or terms and conditions with respect to that data sharing. Also important is what is not regarded as confidential information. So things that are, as you see here, generally available or known to the public, or becomes available through an independent source, typically, those are not considered. That's not considered confidential. Then you will write something about this clause number 2 here is about disclosure required in order to notify if there is a requirement for disclosure. After the purpose of the sharing is complete, there should be a clause here, number 3, as regarding the return of that confidential information or destruction of it. There is a clause also about that no other party should negotiate or otherwise pursue another purpose with this information. And then there are remedies which are for breach of the confidentiality agreement. It's important to have some sense of how long this arrangement will exist, as it's not going to be indefinite, as well as the fact that the rights won't transfer to other parties at a later date. Here you will write the province that you are located in. That's important because it's the jurisdiction that will set out if for resolving disputes here. So it's the governing law clause. And then entire agreement means that this document is going to be the sole written understanding as between the parties. So everything that has been negotiated up until this point has been now reduced into this written document, and we're going to use this in the case of dispute. Severability is a term used by lawyers to continue the agreement to be in force if there's any agreement, if there's any term within the agreement that is regarded as that is voided or voidable by made voidable by the court. Uh, 11 is about assignment. So typically you don't want these rights and obligations to be assigned. And no waiver means that, unless you have explicitly or expressly waived, your right to confidentiality, then it will remain in force. Cumulative remedies means that, these are litigation under this agreement is in addition to and not a substitute for any other legal right that you may have. And it's the agreement in number 14 here is for the sole benefit of the parties and their respective companies or affiliates. Any notice here, you'll have there's a clause around notice, and you can determine how you want notice to be received and what constitutes a valid notice. So it's very important that notice is provided in a specific way to be regarded as valid. And the counterparts clause means that you can use this document and in parts, and it'll still be valid. And then lastly, you have a signature page, which you're going to sign both parties executing that agreement. So that is the confidentiality agreement in a nutshell. If you have any questions, please let me know.